to Human Monsters. Today we look at wrongful convictions, the stolen lives, and the parties responsible. Imagine being accused of a crime you didn't commit. The police, the courts, the jury, the prosecuting attorneys, the community, they're all convinced of your culpability, despite a lack of concrete evidence. You watch helplessly as you are sentenced to life in prison. This happens frequently, and in some cases people die in prison, whether due to old age, the administration of the death penalty, or becoming a casualty of the violence endemic to prison culture. Many lives have been lost while the real criminals walk the streets, enjoying their freedom. Sometimes justice is sacrificed to ensure conviction, so that the failures of law enforcement agencies are kept under wraps and its most prominent figures can save face. Such a state of affairs is likely when the legal system is staffed, in part, with human monsters. The 5 primary reasons for wrongful convictions are eyewitness misidentification, unvalidated forensic science, false confessions, police misconduct, and so-called, quote, snitch testimony. Some statistics on wrongful convictions. 1 in 25 people waiting on death row are innocent. The Innocence Project, an organization that advocates legally for the exoneration of wrongfully convicted persons, reports that 2 to 5% of incarcerated persons are innocent. That means that out of the 2 million inmates in the United States, approximately 40,000 have been wrongfully imprisoned. 20% of the 149 people who were falsely accused of crimes in 2005 were exonerated due to false confessions. 40% of the 149 wrongful convictions in 2005 were due to official misconduct, which consists of illegal or inappropriate conduct by police. The 3 cases of wrongful conviction covered in this episode are the West Memphis 3, Rubin Hurricane Carter, and David McCallum. The West Memphis 3. The crime. On May 5, 1993, in West Memphis, Arkansas, Stephen Branch, Michael Moore, and Christopher Byers, all 8 years old, did not return to their family homes in the evening and were reported missing. The first to submit a missing person report around 7 p.m. was Byers' adoptive father, John Mark Byers. According to a party who alleged to have been the last to see the boys, they were witnessed by 3 neighbors, as noted in affidavits, playing together around 6:30 p.m. They also reported seeing Steve Branch's stepfather, Terry Hobbs, calling Steve to come home. The police conducted a limited search that night, but were unsuccessful in locating the boys. Friends and neighbors of the boys' families conducted a search of their own that evening. They searched the general area where the boys were eventually located, but their scrutiny was not sufficiently thorough. The following day, at around 8 a.m., police conducted a more thorough search for the boys. They were led by personnel of the Crittenden County Search and Rescue Unit. They canvassed all of West Memphis, focusing primarily on Robin Hood Hills, the area in which the boys lived and were assumed to have gone missing, as it was there where they were reportedly last seen. They formed a human chain when they searched Robin Hood Hills. They did not find the boys at that time. Around 1:45 p.m., juvenile parole officer Steve Jones spotted a boy's-sized black shoe floating in a muddy creek that led to a drainage canal in Robin Hood Hills. During a subsequent search of the ditch, the bodies of the boys were discovered. They were stark naked and hogtied with their own shoelaces. Their right ankles were tied to their right wrists, and the same was done with their left ankles and wrists. Their clothing was in the creek. Some of their clothing was twisted around sticks that had been placed in the muddy ditch bed. Most of the clothing was turned inside out. 2 pairs of the boys' underwear were never found. Lacerations were found on various parts of Christopher Byers' body. His scrotum and penis were mutilated. According to forensic pathologist Frank J. Peretti, who conducted the autopsies, Christopher Byers died of multiple injuries, while Michael Moore and Stephen Branch died of multiple injuries with drowning. Police suspected that the boys were raped. Later, however, expert testimony contradicted this speculation, despite the fact that trace amounts of sperm DNA were found on a pair of pants that were found at the scene. Experts for the prosecution claim that Byers' wounds were inflicted by a knife and that he was deliberately castrated by the murderer. Experts for the defense claim that the injuries were more likely due to post-mortem animal predation. Police believe the boys were assaulted and killed at the location where they were found. This theory had its critics, who felt that the assault was unlikely to have occurred at the creek. Victims: Christopher Byers, Steve Branch, and Michael Moore were close friends. They were students of Weaver Elementary School, where they were second-grade students at the time of the murders. They were enthusiastic participants in their local Cub Scout pack. Stephen Edward Branch was the son of Stephen and Pamela Branch. He was an honor student. His parents were divorced, and he lived with his mother, his stepfather, Terry Hobbs, and his 4-year-old half-sister, Amanda. Stephen was buried in Mount Zion Cemetery in Steele, Missouri. Christopher Mark Byers was the son of Melissa DeFeer and Ricky Murray. His parents divorced when he was 4 years old. His mother soon after married John Mark Byers, who adopted Christopher. To quote Melissa Byers, he still believed in the Easter Bunny and Santa Claus. Christopher was buried in Forest Hill Cemetery East in Memphis, Tennessee. James Michael Moore was the son of Todd and Dana Moore and brother to sister Dawn. Of the 3 boys, he was the most passionate about being a Cub Scout. He would wear his scout uniform on days when he did not attend meetings. He wore a blue Boy Scouts of America t-shirt and an orange and blue Boy Scout hat when he was last seen. He was considered the leader of the 3 boys. Michael was buried in Crittenden Memorial Park Cemetery in Marion, Arkansas. In 1994, a memorial was installed for the 3 victims on the playground of Weaver Elementary School. Suspects: 3 individuals were suspected of having committed the murders. Jesse Miskelly Jr., 17 years old. Jason Baldwin, 16 years old. Damian Eccles, 18 years old. James Baldwin and Damian Eccles both had criminal records. Baldwin had been arrested for vandalism and Eccles for shoplifting. Miskelly had a reputation for being short-tempered and frequently engaged in fisticuffs with other boys at his high school. Unlike Eccles and Miskelly, who both dropped out of school, Jason Baldwin was academically successful. He also demonstrated an aptitude for illustration and was encouraged by his art teacher to study graphic design in college. Eccles and Baldwin were close. They knew Miskelly from school, but were only loosely acquainted with him. Damian Eccles and Jason Baldwin bonded over their taste in music and literature. They both enjoyed heavy metal music like Metallica and horror fiction by the likes of Stephen King. They were further united over their frustrations with the cultural climate of West Memphis, which is deeply conservative and Christian, situated as it is in the middle of the so-called Bible Belt. Eccles had a troubled childhood. His family was indigent and was frequently visited by social workers. He rarely attended school. Once, as a teen, he and a girlfriend ran away. They broke into a trailer seeking refuge from a rainstorm. They were arrested, though only Eccles was charged with burglary. As a teen, Eccles spent several months in a psychiatric hospital in Arkansas. Following this, he received full disability status from the Social Security Administration. During his trial, Dr. George W. Woods testified for the defense that Eccles suffered from the following: serious mental illness characterized by grandiose and persecutory delusions, auditory and visual hallucinations, disordered thought processes, substantial lack of insight, chronic, incapacitating mood swings. At his death penalty hearing, Eccles' psychologist reported that months before the murders, Eccles informed him that he obtained superpowers by drinking human blood. At the time of his arrest, he was working part-time for a roofing company and was expecting a child with his then-girlfriend, Dominique Tier. Alternative suspects. In the early stages of the investigation, 2 other teenagers native to the West Memphis area were regarded as possible suspects, Chris Morgan and Brian Holland. Both had been arrested for drug-related offenses. Their abrupt and hasty departure for Oceanside, California, 4 days after the bodies of the victims were located, aroused suspicion. Chris Morgan was presumed to have been familiar with the 3 boys to some extent, since he had driven an ice cream truck in their neighborhood. When Morgan and Holland were found and arrested in Oceanside on May 17, 1993, they both submitted to polygraph examinations administered by California police. The polygraph examiners reported that both men's results indicated deception when they denied involvement with the murders. During subsequent questioning, Morgan indicated that he had a long history with substance abuse, which consisted of frequent blackouts and memory lapses. He said that he might have killed the boys, but soon after recanted this part of the statement. California police sent samples of the men's blood and urine to the West Memphis Police Department, but there is no record of the WMPD investigating Morgan or Holland as suspects following their arrest in California. The relevance of Morgan's recanted statement was debated in trial, but was eventually barred from admission as evidence. Another alternative suspect was known as Mr. Bojangles. The suspect in question was described as an African-American male during the beginning of Jesse Miskelly's trial. According to the WMPD, on the evening of May 5, 1993, at 8:42 p.m., employees of the Bojangles restaurant, located about a mile from the crime scene in Robin Hood Hills, reported seeing a black male who appeared to be, quote, mentally disoriented inside of the restaurant's ladies' room. The man was bleeding and had brushed up against the washroom's walls. WMPD officer Regina Meeks responded to the call. She took a statement from the restaurant's manager through the eatery's drive-through window. By the time she arrived, the man had left, and the police did not examine the scene inside of the ladies' room on that day or any future date. The day after the boys were found, Marty King, then manager of Bojangles, realized there was a possible connection to the bleeding man who was found in the ladies' room of the restaurant and the murders. He reported this to the police, who then inspected the ladies' room. King gave the officers a pair of sunglasses he remembered as having been left behind by the man. The detectives took blood samples from the walls and tiles of the ladies' room. Detective Bryn Ridge testified that at a later date, he lost the blood scrapings. A hair identified as belonging to a black male was later recovered from a sheet that was wrapped around the body of one of the boys. Investigation, evidence, and interviews. WNPD officers James Sudbury and Steve Jones felt that the crime had, quote, cult overtones to it, and that Damien Eccles might have had a hand in it because he was known to have an interest in the occult. He was involved in a local Wiccan group, but many believe that he was, in fact, a committed and active Satanist. Jones also felt that Eccles was capable of murdering children. Damien Eccles was interviewed on May 7th, 2 days after the bodies were found. He underwent a polygraph examination, whereupon he denied any involvement with the crime. The polygraph examiner claimed that Eccles' results indicated deception. On May 9th, during a formal police interview with Detective Bryn Ridge, Eccles mentioned that one of the victims was wounded in his genitalia. The attendant officers viewed this statement as incriminating. As a month passed with little progress in narrowing down a suspect, Police continued their focus on Eccles, stalking him, maintaining surveillance of his family's home. As the investigation gathered steam, Eccles was interrogated more often than any other suspect. Despite all this, they claimed he was not regarded as a direct suspect, but merely as a source of information. On June 3rd, Jesse McCallum was interrogated by police. McCallum was questioned alone, despite the fact that his reported IQ was 72, which is categorized as borderline intellectual functioning. Because he was a minor, his parents should have been present during the interrogation. He was questioned alone. McCallum's father gave permission for McCallum to go with the police, but did not explicitly give his consent for his son to be questioned or interrogated. His father was not advised of his son's rights to have an attorney present during the interrogation. McCallum was questioned for approximately 12 hours. Only 2 segments were recorded, totaling 46 minutes combined. McCallum soon recanted his confession, insisting that he only confessed under pressure from the police, who employed techniques of intimidation, coercion, fatigue, and veiled but unmistakable threats. McCallum noted that he was, quote, scared of the police throughout the confession. Though he was informed of his Miranda rights, he reported later that he did not understand them. In 1996, the Arkansas Supreme Court ruled that McCallum's confession was voluntary and that he did understand his Miranda rights and the consequences of his confession. Portions of his confession were leaked to the media and reported on the front page of the Memphis Commercial Appeal before the trials began, likely influencing the jury. Shortly after McCallum's first confession, Eccles and Baldwin were taken into custody. On February 17, 1994, 8 months after Jesse McCallum's first confession, he made another statement to the police. His attorney, Dan Stidham, was present and persistently advised McCallum not to say anything. McCallum ignored this advice and went into detail about the most violent aspects of the crime. Years later, when Stidham had been elected to a municipal judgeship, he wrote a detailed critique of the process, which he insists contained numerous errors by police and misconceptions throughout the investigation. Vicki Hutchison. Vicki Hutchison recently moved to the West Memphis area at the time of the crime and soon played a crucial role in the investigation. She later recanted her testimony, claiming her statements were coerced by police. On May 6, 1993, before the victims' bodies were found, Hutchison underwent a polygraph exam by Detective Don Bray at the Marion Police Department. She was accused of stealing money from her employer, and the test would determine her guilt or lack thereof. Her son Aaron was present and proved to be such a persistent distraction that Bray was unable to perform a satisfactory examination. At one point, Aaron, who had been a playmate of the boys, told Bray that the boys were killed at a location known as, quote, the Playhouse. After the bodies were found at the spot indicated by Aaron, Bray probed Aaron for more details. Aaron informed Bray that he witnessed the murders and that they were committed by Satanists who spoke Spanish. He elaborated further, with his follow-up statements being notably inconsistent. He was shown photos from lineups and was unable to identify Eccles, Baldwin, and McCallum. There was also no so-called playhouse at the murder scene. An officer leaked portions of Aaron's statements to the media, which contributed to the fervently held belief among residents of West Memphis that the murders were the centerpiece of a satanic ritual. Wherever Eccles went, he overheard conversations about Satanism. It was rumored that there was a large group of Satanists operating as a cabal in the area and that nobody's children were safe. Pressure mounted on the West Memphis Police Department. They were unprepared for a crime of this magnitude. They were accustomed to traffic violations, theft, vandalism, minor drug offenses, and other forms of petty crime. Not only was a triple murder unheard of in the area, but the fact that the victims were prepubescent children sparked widespread panic throughout the community. Anxious parents worried that their children could be next. The parents of the boys and all other concerned citizens wanted answers, and they wanted someone behind bars. The phones at the WMPD rang off the hook day and night, and the officers felt the pressure acutely. They were desperate to fill handcuffs, and if that meant violating protocol, so be it. Around June 1st, 1993, police persuaded Vicki Hutchison to place hidden microphones in her home during a visit from Eccles. Miss Kelly knew Hutchison initially and agreed to introduce her to Eccles. Hutchison didn't report any incriminating statements made by Eccles during her conversation with him. Police found the conversation to be inaudible. Hutchison claimed it was audible. On June 2, 1993, Hutchison told police that about 2 weeks after the murders, she, Miss Kelly, and Eccles attended a Wiccan meeting in Terrell, Arkansas. Hutchison claimed that during the meeting, an intoxicated Eccles bragged openly about killing the 3 boys. Miss Kelly was questioned on June 3, 1993, the day after Hutchison's confession, about the events that transpired at the Wiccan meeting. Hutchison was unable to recall the location of the meeting and didn't name any of the other participants of the meeting. Hutchison was never charged with the allegation of theft. She claims she implicated Eccles and Miss Kelly only to avoid facing criminal charges. She was further motivated by the reward that was offered for the disclosure of the murderers' identities. Trials. Jessie Miss Kelly was tried in a separate trial due to the Bruton Rule, which stated that Miss Kelly's confession could not be admitted against Eccles and Baldwin, his co-defendants. Damien Eccles and Jason Baldwin were tried together. They all pled not guilty. During Miss Kelly's trial, expert testimony was given by Dr. Richard Ofsha. He was a professor of sociology at UC Berkeley. He was an expert on false confessions and police coercion. His verdict on the recording of Miss Kelly's interrogation was that it was a classic example of police coercion. Other critics have pointed out that Miss Kelly's so-called confessions bore a number of discrepancies. Descriptions of details of the crime scene and the murder victims often differed noticeably. This included his so-called admission that he watched as Eccles sexually assaulted one of the boys. Initially, police suspected that rape had occurred because their anuses were dilated. However, no forensic examination provided evidence that sexual assault occurred as a precursor to the murders. Dilation of the anus is a typical post-mortem process. On February 5, 1994, the jury found Miss Kelly guilty of 1 count of first-degree murder and 2 counts of second-degree murder. The court sentenced him to life plus 40 years in prison. His lawyers filed an appeal, but the conviction was affirmed by the Arkansas Supreme Court. Eccles and Baldwin were tried 3 weeks later. The prosecution accused them of committing a satanic murder. Dale W. Griffiths, a graduate of the unaccredited Columbia Pacific University, was called to testify by the prosecution. Griffiths was an expert on the occult and was considered the best possible authority to verify that the murders were part of a satanic ritual. This, despite the fact that no materials were found at the scene that would indicate that such a rite had taken place. On March 19, 1994, Eccles and Baldwin were found guilty on 3 counts of murder. Eccles was sentenced to death, and Baldwin to life in prison. The defense team argued that Eccles' knowledge of the genital mutilation was most likely due to news articles he may have read. He further insisted that Eccles' knowledge of the crime was strictly limited to what he would have learned from televised coverage of the crime. The prosecution rejected this argument, stating that Eccles' knowledge of the details of the crime was too close to the facts, since it was not reported to the public that drowning occurred and one victim was mutilated more than the others. In Eccles' testimony, he noted that Detective Ridge's description of their earlier conversation, which was not recorded and covered the aforementioned details, was inaccurate. He also stated that other claims by Ridge were outright lies. Investigative journalist Mara Leverett argues in her book Devil's Knot that information of the crime Eccles was privy to that may not have been disseminated to the media might have come from police leaks, which emerged frequently. Such information would have included Detective Gitchell's comments to Mark Byers that were circulated to the public. The defense team objected when the prosecution attempted to question Eccles about his history of unrelated violent behavior, but these objections were overruled. Criticisms. The WMPD attracted widespread criticism for the way it handled the crime scene. According to Miss Callie's former lawyer, Dan Stidham, there were numerous serious errors made by police at the scene of the crime. He characterized the scene as, quote, literally trampled, especially the creek bed. He went on to say that the bodies were removed from the water before the coroner arrived to examine the scene and determine the state of rigor mortis. Such information is crucial to ascertaining vital details about the crime. Instead, the bodies were allowed to decay on the creek bed and were exposed to sunlight and insects. In fact, the police didn't call the coroner until almost 2 hours after the discovery of the floating shoe. This resulted in the coroner arriving late. Timing is a crucial element of a coroner's analysis. Officials failed to drain the creek in a timely manner. Had they done so, they would have secured possible evidence in the water. Instead, the creek was sandbagged after the bodies were retrieved from the water. Stidham has called the coroner's investigation extremely substandard. A small amount of blood was found at the scene that was never tested. According to the HBO documentaries Paradise Lost, The Child Murders at Robin Hood Hills, and Paradise Lost 2, Revelations, no blood was found at the crime scene. One conclusion drawn from this was that the location where the bodies were found was not necessarily the spot where the murders actually happened. After the initial investigation, the police failed to control disclosure of information and speculation about the crime scene. To quote Mara Leverett, police records were a mess. To call them disorderly would be putting it mildly. She too speculated that the local police were overwhelmed by the crime, which was unlike anything they had ever encountered. Assistance was offered by the violent crimes experts of the Arkansas State Police. Critics have suggested that this was due to the fact that the WMPD was under investigation by the Arkansas State Police for suspicion of theft from the Crittenden County Drug Task Force. Leverett went on to note that some of the physical evidence was stored in paper supermarket bags, which even bore the name of the supermarket on the bags. Evidence was supposed to be stored in the appropriate type of receptacles that can contain evidence in a way that protects it from contamination. As police speculated about who could be responsible as an assailant, a juvenile probation officer assisting the officers at the scene of the murders speculated that Eccles was, quote, capable of committing the murders. To quote the probation officer, "It looks like Damien Eccles finally killed someone." Forensic scientist and criminal profiler Brent Turvey stated in the film Paradise Lost 2 that human bite marks could have been found on at least one of the bodies. Bite marks were found but were only noticed in photographs years after the trials and were not inspected by a board-certified medical examiner until 4 years after the murders. The expert for the defense testified that the mark in question was not made by an adult. Other experts testified that there were no bite marks. The state's experts examined the bodies for marks, while others conducted photo analysis of their injuries. Appeals. In May 1994, all 3 defendants filed appeals. The convictions were upheld on direct appeal. Miss Kelly's lawyer Dan Stidham prepared an appeal to the U.S. Supreme Court in June 1996. In 2007, Eccles petitioned for a retrial. This was based on a statute that permits post-conviction testing of DNA evidence due to technological advances that have been made in the field of DNA analysis since 1994. This was seen as a possible route to exoneration for the wrongfully convicted. This petition was thwarted when David Burnett, the presiding judge over Eccles' original trial, barred this information in his court. The ruling was in turn thrown out by the Arkansas Supreme Court as to all three defendants on November 4, 2010. In an interview for one of the Paradise Lost documentaries, Burnett stated his firmly held belief that the West Memphis Police Department's methods were sound and that his faith in the organization was unwavering. John Byers' knife. John Mark Byers, Christopher Byers' adoptive father, gave a knife to a cameraman named Doug Cooper. Cooper labored under the employ of documentary makers Joe Berlinger and Bruce Sinofsky, who made the Paradise Lost films. Byers gave Cooper a folding hunting knife that was manufactured by Kershaw. According to statements given by Berlinger and Sinofsky, Cooper informed them that he had received the knife on December 19, 1993. After the film crew returned to New York City, Berlinger and Sinofsky discovered what appeared to be blood on the knife. HBO executives ordered them to submit the knife to the West Memphis Police Department. Receipt of the knife was not documented by the WMPD until January 8, 1994. Initially, Byers claimed the knife had never been used. After being informed there was blood on the knife, Byers claimed he used it only once and that he used it to cut deer meat. He was told that DNA analysis determined the blood matched his and Christopher's blood type. Byers insisted he had no idea how the blood got onto the knife. Throughout the WMPD's interrogation of Byers, the police suggested to him that he might have left the knife out accidentally, and Byers concurred. Byers speculated that he may have cut his thumb with the knife. Further testing was done on the blood. Results were inconclusive about the source of the blood. Uncertainty persisted due to the fact that the amount of blood was minute, and because both John and Christopher had the same HLA-DQA genotype. John Byers agreed to submit to a polygraph examination. He passed the test when questioned about the murders during the filming of Paradise Lost 2 Revelations, but the film revealed that Byers was under the influence of psychoactive prescription medications that may have skewed the results of the test. Possible dental imprints. After their convictions, Eccles, Baldwin, and Miss Kelly submitted imprints of their teeth. These were compared to the alleged bite marks that were said to be located on Steve Branch's forehead, which were not mentioned in the original autopsy or trial. No matches were found. John Mark Byers had his teeth removed in 1997 after the first trial, but before an imprint could be made. In stating his reasons for having his teeth extracted, he gave contradictory answers. On one occasion, he claimed that the medication he took to control seizures caused periodontal disease, and that he had his teeth removed for other dental problems that had persisted for years. One of the experts who examined the autopsy photos noted that he saw what appeared to be the imprint of a belt buckle on Christopher's corpse. John Byers revealed that he spanked Christopher with a belt shortly before he went missing. Vicki Hutchison's recantation. In October 2003, Vicki Hutchison, who had played a significant role in securing the arrests of Eccles, Baldwin, and Miss Kelly, was interviewed by the Arkansas Times and revealed that every time she spoke to the police germane to the subjects and their activities around the time of the crime was fabricated. She went on to note the implication on the part of the police was that if she didn't cooperate with the investigation, they would arrange to have her custody of her child confiscated. She said that during her visit to the police station, there were photographs of Eccles, Baldwin, and Miss Kelly attached to the wall, and that the officers were throwing darts at them. New evidence. In 2007, DNA collected from the crime scene was finally tested. None matched DNA extracted from Eccles, Baldwin, and Miss Kelly. A hair that was, quote, not inconsistent with Stephen Branch's stepfather, Terry Hobbs, was found tied into the knots that were used to bind one of the victims. The prosecution conceded that no DNA evidence tied the accused to the crime scene, but said The state stands behind its convictions of Echols and his co-defendants. On May 5, 2009, Pamela Hobbs declared in the United States District Court in the Eastern District of Arkansas, Western Division, that, quote, one hair was consistent with the hair of Terry's friend, David Jacoby. To further quote Pamela Hobbs, additionally, after the murders, my sister Jo Lynn McCallum and I found in Terry's nightstand a knife that Stevie carried with him constantly, and which I believe was with him when he died. It was a pocket knife that my father had given to Stevie, and Stevie loved that knife. I had been shocked that the police did not find it with Stevie when they found his body. I had always assumed that my son's murderer had taken the knife during the crime. I could not believe it was in Terry's things. He had never told me that he had it. Also, my sister Jolyn told me that she saw Terry wash clothes, bed linens, and curtains from Stevie's room at an odd time around the time of the murders. There was additional new evidence discovered in 2007 that I cannot now recall. Jury misconduct. It was revealed in July 2008 that Kent Arnold, the jury foreman on the Echols-Baldwin trial, discussed the case with an attorney prior to the beginning of deliberations. Arnold was accused of advocating for the guilt of the West Memphis Three and sharing knowledge of inadmissible evidence, like statements by Jesse Miskelly, that were barred from the proceedings with other jurors. When these allegations came to light, legal experts agreed that Arnold's conduct could result in the reversal of the convictions of Echols and Baldwin. In September 2008, attorney and now judge Daniel Stidham, who represented Miss Kelly in 1994, testified at a post-conviction relief hearing. Under oath, Stidham testified that Judge David Burnett erred by communicating with the jury during their deliberations, which is strictly forbidden by law. Stidham reported that he overheard Burnett discuss taking a lunch break with the jury foreman and heard the foreman remark that the jury was nearly done with the deliberations. To quote Stidham, Burnett's response was, "You'll need food for when you come back for sentencing." The foreman followed up by asking what would happen if the defendant was acquitted. Stidham said the judge closed the door without responding. Stidham acknowledged that his failure to document this incident on the official court record and his failure to meet the minimum requirements in state law to represent a defendant in a capital murder case by all available means was evidence of ineffective assistance of counsel. Bearing this in mind, Stidham felt that Miss Kelly's conviction should be vacated. Request for retrial. On October 29, 2007, documents were filed in federal court by Echols' defense attorneys, seeking a retrial or his immediate release from prison. The filings cited DNA evidence linking Terry Hobbs, the stepfather of one of the victims, to the crime scene, supported by recent statements from Hobbs' ex-wife. Additionally, new expert testimony that the supposed knife marks on the victims, including the mutilations of Byers' genitals, were the product of animal predation after the bodies were deposited near the creek. Once again, Judge David Burnett refused to admit DNA evidence. On September 10, 2008, Burnett, by then a circuit court judge, denied the request for a retrial, ruling that the DNA tests were inconclusive. The ruling was appealed to the Arkansas Supreme Court. Verbal arguments were heard there on September 30, 2010. Arkansas Supreme Court ruling. On November 4, 2010, the Arkansas Supreme Court ordered a lower judge to rule on whether the newly analyzed DNA evidence should exonerate the West Memphis Three. The justices also ordered the lower court to examine the claims of misconduct among those who sentenced Damian Echols to death and Jason Baldwin to life in prison. In December 2010, David Burnett was elected to the Arkansas State Senate. Circuit Court Judge David Lacer replaced Burnett and presided over the evidentiary hearings mandated by the successful appeal. Alford plea. On August 19, 2011, following weeks of negotiations, the West Memphis Three were released from prison as part of a plea deal. This rendered the hearings ordered by the Arkansas Supreme Court redundant. They entered unusual Alford plea deals. The Alford plea is a legal mechanism that enables defendants to plead guilty while still asserting their actual innocence in cases where the defendants concede that prosecutors have sufficient evidence to secure a conviction. The plea was negotiated with prosecutors by Stephen Braga, an attorney with Ropes and Gray, who represented Eccles on a pro bono basis beginning in 2009. Pursuant to this deal, Judge Davis Lacer vacated the previous convictions, including the capital murder convictions for Eccles and Baldwin. A new trial was ordered. Eccles and Baldwin proceeded to enter Alford pleas to lesser charges of first and second degree murder while verbally stating their innocence. Judge Lacer sentenced them to time served, a total of 18 years and 78 days, and they were both given a suspended imposition of sentence for 10 years. If they reoffend, they can be sent back to prison for as long as 21 years. Conditions cited by prosecutor Scott Ellington for agreeing to the plea deal included that 2 of the victims' families join the cause of the defense. Also that the mother of a witness who testified about the nature of Eccles' confession questioned the integrity of her daughter's statement. Another consideration was that the state crime lab employee charged with collecting fiber evidence at the Eccles and Baldwin homes after they were taken into custody had died. As part of the plea deal, the 3 men cannot pursue litigation against the state for wrongful imprisonment. Reaction to the success of the Alford plea were not all positive. Both supporters of the West Memphis Three and their opponents, who still felt they were guilty, were dissatisfied with the conditions of the deal. In 2011, supporters of the West Memphis Three pressured Arkansas Governor Mike Beebe to pardon them based on their innocence. Beebe denied the request, stating he did not feel there was sufficient evidence to prove that someone else committed the murders. Prosecutor Scott Ellington said that the Arkansas State Crime Laboratory would seek other suspects by running searches on all DNA samples produced in private lab tests during the defense team's investigation. This would include having them tested by the FBI's combined DNA index system database. Ellington went on to say that although he was still convinced of the West Memphis Three's guilt, they would likely be acquitted in the event of a new trial because of the powerful legal counsel available to them, the loss of key evidence over time, and the change of heart by some of the witnesses. Reactions by law enforcement and the victims' families. The families of the victims are divided in their opinions regarding the innocence or guilt of the defendants. In 2000, Christopher Byers' biological father, Ricky Murray, expressed his doubts about the guilty verdicts on the official West Memphis 3 website. In 2007, Pamela Hobbs, mother of Steve Branch, joined the chorus of those who publicly questioned the verdicts. She called for reopening of the verdicts and further investigation of the evidence. In late 2007, John Mark Byers, who at one time had stridently believed that the West Memphis Three were guilty, announced that he now believed that they were innocent. To quote Byers, "I had made the comment, if it were ever proven the 3 were innocent, I'd be the first to lead the charge for their freedom and take every opportunity that I have to voice that the West Memphis 3 are innocent, and the evidence and proof prove they're innocent." Byers went on to speak to the media on behalf of the West Memphis 3, and he expressed a desire for justice both for the families of the victims and the accused. In 2010, District Judge Brian S. Miller ordered Terry Hobbs, stepfather of Steve Branch, to pay $17,590 to Dixie Chicks vocalist Natalie Maines for legal costs due to a defamation lawsuit he filed against the band. Miller dismissed a suit Hobbs filed due to Maines' remarks and writings, implying that he was involved in his stepson's murder. The judge declared that Hobbs had chosen to involve himself in public discussion over whether the convictions were just. John E. Douglas, a former longtime FBI agent and criminal profiler, said that the murders were more likely the type that would be committed by a single killer, and that part of his agenda involved degradation and punishment of the victims. He felt that a trio of, quote, unsophisticated teenagers were incapable of committing such a crime. Douglas's theory about the killer was that he had a history of violence and was familiar to the victims and with the local topography. As part of his credentials, Douglas was a former FBI unit chief for 25 years of the Investigative Support Unit of the National Center for the Analysis of Violent Crime. He stated in his report for Eccles' legal team that there was no evidence that satanic rituals were involved in the murders, and that the alleged knife injuries would most likely have been due to animal predation. He ruled that the victims died from a combination of blunt force trauma and drowning. He believes the killer's agenda was motivated by personal pathology. The following is a portion of Damien Eccles' interview with Katie Couric.
It's been 3 years since you were released from prison.
Yes.
And what has your life been like for the last 3 years?
It's odd, you know, whenever you get out of prison, people think you're just going to be excited and happy that you're out. And you are, but at the same time, there's a lot of shock and trauma and everything else that goes along with that. I had been in solitary confinement for almost 10 years before I was released. You know, the last time I had seen a computer was, I believe, 1986 or 1988. And back then it was basically a glorified typewriter for rich people. It wasn't connected to the internet or anything. I'd never used a cell phone or an ATM card or any of that.
So it was a major adjustment.
Huge, and I'm still adjusting.
Many people say that you and Jesse and Jason became targets of the police, or by the police. You were targeted. Why do you think that was the case? Why do you think they rushed to judgment, if you will?
We came from a very hardcore, fundamentalist, right-wing Bible Belt town, where anyone who didn't fit in with, you know, the local ideology or political climate or anything else was,
or even appearance, right?
Exactly. The way I dressed, the music I listened to, the books I read. You know, as evidence at the trial, they actually introduced things like Stephen King novels. They said that was proof that I was satanic.
And when you heard the verdict in that courtroom of guilty, I understand it was really an out-of-body experience for you in many ways.
The only thing I can describe it as is if you've ever been beaten. You know, if you've ever been punched in the head, a lot of times it doesn't always immediately register as pain. It's more like a bright flash of light and a loud noise, and you're so disoriented you can barely keep your feet up under you. And that's what it's like hearing yourself sentenced to death. It's like being beaten repeatedly in the head. I was sentenced to die not once and not twice, but 3 times. They sentenced me to die over and over and over again.
The documentary Paradise Lost, the HBO doc, came out in 1996. And it seemed as if that really started the movement of people questioning why you were convicted of this crime, why you were serving time. Do you think that's when this all started?
Absolutely. You know, I always tell people that this case is nothing out of the ordinary. Stuff like this happens to people all the time in the judicial system. The only thing that made our case exceptional was they had cameras in the courtroom. They called the trial on film. If not for that, they would have killed me and this would have been swept under the rug and completely forgotten about. But due to the fact that they got it on film, it spurred people on to do everything from have bake sales and benefit concerts to putting together websites. And every time there was a court hearing, people would show up at the Capitol to hold signs and protest. That was what really got the ball rolling. That saved my life.
And all these celebrities, as I mentioned, people like Eddie Vedder, Johnny Depp, the director Peter Jackson, they all gravitated towards your case and they became crusaders for you. Why? What was it about your case that made them want to really step in and take serious action, like Peter Jackson hiring investigators, doing all kinds of things on your behalf?
I think it was a couple of different things. One with people like Eddie Vedder and Johnny Depp. You know, not only did they come to our aid in the case, but over the years they became as close as biological family to us. And they've always said what it was with them was the fact that whenever they first saw me, they first saw the film footage, they realized if it would have been them in that same place at that same time, that they would have been the targets. They would have been the outcasts. For Peter, it's more the fact that Peter hates bullies. He can't stand bullies. And he saw someone with no ability to defend themselves being picked on by the state, and he wanted to even the playing field.
I know that in your case, something called the Alford plea was used as a way to really get you out of prison.
Yes.
Can you explain what that is and why it was used?
It's really rare, bizarre, and nonsensical. What an Alford plea means is you're accepting a guilty plea and maintaining your innocence at the same time. The reason it exists is so that it sort of brings closure to a case, and it prevents the state from being held responsible for what they've done. They don't have to compensate you in any sort of way or ever admit that they made a mistake. People ask me, did I have a hard time accepting that, coming to terms with it, taking that plea? And the answer is no, because I'd been in prison for almost 20 years. I was losing my eyesight. My health was degenerating rapidly. On death row, there's almost no such thing as medical care and dental care. They're not going to spend a lot of time and money and energy taking care of someone they plan on killing. I was literally dying. I knew that if I did not take this deal, I was never going to live to see the outside of those walls.
So it was something you felt compelled to do. On the other hand, does it infuriate you that the people responsible for this miscarriage of justice will never be held accountable?
It does. Not one single person has been or will ever be held responsible. People have built careers for themselves off of this case, and none of them will ever be brought to justice because of it.
Do you think that the authorities will ever find out who really killed those 3 boys?
I think what will have to happen, the people that are in office, the people that hold those positions right now, those people will either have to retire or move on, and new people that don't have a vested interest in keeping it covered up will have to come into these positions. Then one day eventually we'll see justice.
This is a sample of a panel discussion involving Damian Eccles, Jason Baldwin, and Jesse Miskelly.
This case has already, not just me, but all 3 of us, it's eaten up 20 years of our lives. So it's not easy to have to keep reliving it, keep talking about it over and over. It's a very, very difficult thing. It feels like it's a continuing violation in a way. But at the same time, I don't want it to just be forgotten, because people think this case is something out of the ordinary. And it's not. It happens to people all the time.
Damien and I would exchange letters through his sister. She'd write me and include a letter from Damien, and I'd write her and include a letter for Damien. And one day the warden called me up to his office and said, "Hey, this has got to stop or I'm going to put you in the hole." And then it was a few years later, the warden called me to his office again. He was like, "Hey, they might be shipping Jesse over here. Do you have any objections to that?" And I'm like, "No. He hasn't done anything wrong. He was forced into that situation, made to cry uncle or whatever you want to say." I was working in the law library, and it was my job to do the legal requests for the guys on death row and on lockdown back there. And at the end of the day, I had to have like a stack of paperwork to send back there. My supervisor, she'd come pick it up. I'd have it on a rolling cart. One day she called and she was like, "Hey, I'm really busy. I can't come get it. Would you bring it to my office?" And so I'm like, "Yeah, no problem." So I was wheeling it down there, and I happened to glance in the visitation window, and I saw Damon and Lori in there. So I tapped on the window. Lori, elbow got Damon's attention. He's got to get his glasses on so he can see me, And we just waved at each other. And about that point, when the guards was like, "Keep it moving, Baldwin," I'm like, "All right." So it was just like just a split second thing, And Damien was so happy about it, he wrote about it in his book, Almost Home. And the night it came out, they took my job away from me.
Mr. Byers and I started corresponding a little right towards the end, whenever we were about to get out. And we sort of reconciled with each other and apologized to each other for the names we had called each other and everything else over the years. And I think he's actually a really great person for doing what he did, standing up for us the way he did, which wasn't easy, with everything he had to put behind him and get over in order to do that. Terry Hobbs, I try not to think about it all. That's the sort of thing that'll drive you crazy if you think about it. If you think someone else was responsible for you losing 18 and a half years of your life, it would drive you insane.
We still keep in touch with, a lot of people today that helped over the years. We still keep in touch with them.
Eddie Vedder used to come and see me at the prison. He would come to death row and visit there, so he was there all the time. Since we've been out also, we had people that didn't just, throw money at the case, but actually got involved on emotional and psychological levels that have been with us through this whole time and are still sticking with us now. Whenever I got locked up, there was no such thing as the internet. I hadn't seen a computer since 1986. I'd never used a cell phone. So there's all of that stuff, but there's also things that people don't think about. I hadn't eaten a fork in almost 20 years, so I was having to learn to use a fork again. I haven't walked with chains without having chains on my feet for almost 20 years. So it literally is, like having to learn to walk again. The first few days I was out, I kept almost falling constantly. So there's lots of those things too.
Right now, I'm just living life, trying to enjoy it, pick up pieces. I got my driver's permit Monday, Just doing normal things. I haven't actually driven yet, but I got the permit. Some friends of mine have assured me that I will be enrolling in the driving school next week, perhaps. So I don't think anybody's brave enough to actually let me drive their car. But, just doing normal things. I'm working on a construction crew. I'm working with a great bunch of guys, and, got my first paycheck. Going to movies, theaters, being with family, friends, people that's been supportive over 2 decades, and just happier than anything just to see us out and wearing normal clothes and without anybody running up saying your visit's terminated or you have 5 minutes left or whatever.
I've been writing again. I want to try to capture all this while it's still new and get it down on paper. Maybe it'll help me digest a little bit of it later. It's in a lot of ways it's felt like every day is a week since we've gotten out. We haven't even been out 2 months yet. And in some ways it feels like prison was years ago already. And it's a lot to digest, and I just want to save it and go back later and get some of the parts that I may be missing now. When I was on death row, I used to get letters from junior high school kids, whole bundles of letters where whole classes would write me. Junior high school kids can come to the conclusion that we're innocent, but the public officials in Arkansas aren't that smart. They knew, they just didn't care. What they were doing was doing anything they could to win the next election. That was their first and only priority. What will win them the next election?
The truth of the matter is, we have alibi witnesses showing, where we were at the times of the crimes, and based on that alone, without anything else, we should be fully exonerated. Governor should grant us pardons, based on the knowledge of our innocence. There are so many cases that go unsolved in America, and for our liberty to be hinged upon finding who really done this it's a almost insurmountable task to put on our shoulders. I'm not aware of any actual investigation the state's doing on its own under its power of law. So it's just really up to the people, to continue to fight to find who really done the crime and to push for our exoneration.
Rubin Carter. Another well-known case of wrongful conviction and imprisonment involves former boxer Rubin "Hurricane" Carter. A film was made about his life called The Hurricane, starring Denzel Washington and directed by Norman Jewison. Carter was born on May 6, 1937, in Clifton, New Jersey. He was the fourth of 7 children. As a child, he had his first run-in with the law when he stabbed a man, allegedly in self-defense, at the age of 11. He was sentenced to assault and served a sentence at a juvenile reformatory. In 1954, Carter escaped from the reformatory and joined the Army. Within months of having completed infantry basic training at Fort Jackson, South Carolina, he was stationed in West Germany. It was in Germany where Carter took up boxing, fighting in an official capacity as a representative for the U.S. Army. In 1956, he was discharged. He was deemed unfit for service after 4 court-martials. Soon after his discharge, Carter fell afoul of the law once again when he was convicted for 2 muggings. He was sent to prison. Boxing career. Following his release from prison in September 1961, Carter pursued a career as a professional boxer. Though he was 5'8", making him shorter than a typical middleweight, he fought all his career at 155 to 160 pounds. He attracted attention due to his aggression and power. Many of his matches ended early as knockouts. His overall 40-match career record consisted of 27 wins, 19 of them by knockout. He became popular with boxing audiences and was dubbed the Hurricane as a reference to his hyperkinetic, blistering fighting style. Other honors followed. Publication The Ring listed him as one of its top 10 middleweight contenders in July 1963, after defeating notable middleweights such as Florentino Fernandez, Holly Mims, Gomeo Brennan, and George Benton. At the end of 1965, he was ranked the number 5 middleweight. Carter's fortunes as a fighter were mixed in 1964 and 1965. He never became a champion, but he received an honorary championship title belt from the World Boxing Council in 1993. He has been inducted into the New Jersey Boxing Hall of Fame. The crime. On June 17, 1966, around 2:30 a.m., 2 men entered the Lafayette Bar and Grill at the intersection of East 18th Street at Lafayette Street in Paterson, New Jersey. They opened fire and killed the bartender, James Oliver, and a patron, Fred Noyaux, both of whom died instantaneously. Another patron, Hazel Tanis, was wounded and survived only to die a month later from shots to her throat, stomach, intestine, spleen, and left lung, as well as having her arm shattered by shotgun pellets. Another survivor, Willie Marins, emerged with a serious injury to his eye, costing him half his sight, but he was otherwise unscathed. When questioned by the police, both Marins and Tanis described the shooters as having been black males. Neither of them identified Rubin Carter or John Ardis. A petty criminal by the name of Alfred Bello, who had been in the neighborhood at the time with intent to burglarize a factory, was counted among the eyewitnesses. According to Bello's testimony, he was approaching the Lafayette when 2 black males, one carrying a shotgun and the other a pistol, came around the corner walking in his direction. He fled the scene and the shooters departed in a white car that was double parked near the Lafayette. Another witness was Patricia Patty Valentine. She lived atop the Lafayette. According to Valentine, she saw 2 black males get into a white car and drive off. Another neighbor gave their account of the incident. Ronald Ruggiero heard the shots and said he saw from his window Alfred Bello running west on Lafayette Street towards 16th Street. Following this, he heard the screech of tires and saw a white car speed past, heading west with 2 black males in the front seats. Bello's and Valentine's descriptions of the car were identical at the time. Initially, Valentine described the real lights as lighting up completely like butterflies. When she testified during the second trial, she gave a more accurate description of Rubin Carter's car, which bore conventional taillights with aluminum decoration in a butterfly shape. A prosecuting attorney's theory about this discrepancy was that it was a product of a misread court transcript by the defense. Investigation, indictment, and first conviction. Hours before the murders, Rubin Carter had been searching for guns that he had misplaced a year earlier. At the time, Carter drove a white Dodge Polara, noted for its out-of-state license plate with a blue background and gold-colored font. The taillights were butterfly-shaped aluminum decoration. Carter's car was pulled over by police 10 minutes after the murders. Since the police were on the lookout for a car carrying 3 passengers, they let Carter go. Minutes later, after receiving a description of the perpetrator's car from Al Bello, the police realized Bello had just described the car they stopped just moments ago. When police caught up with Carter's car, they pulled him over and brought Carter and a passenger, John Ardis, to the Lafayette 31 minutes after the murders. No fingerprints were taken at the scene, and no facilities were available to test Carter and Ardis for gunshot residue. While searching Carter's car 45 minutes later, Detective Emile de Robiel found a live .32 caliber pistol round under the front passenger seat and a 12-gauge shotgun shell in the trunk. After a firearms identification process had been completed on the murder weapons, it was declared that the weapons used to commit the murders at the Lafayette were a .32 caliber pistol and a 12-gauge shotgun. The defense raised questions about the methodology of the evidence gathering, since it was not logged with a property clerk until 5 days after the murders. The prosecution countered this by producing a report lodged 75 minutes after the murders that documented the presences of the .32 caliber pistol round and the 12-gauge shotgun shell. The defense was able to demonstrate that the bullet found in Carter's car was brass cased instead of copper coated, like those found at the scene of the crime. The shotgun shell found in Carter's car was an older model than those found at the scene, bearing a different wad and color. Countering this, the prosecution argued that the metal and make of the ammunition retrieved was meaningless because the ammunition found at the crime scene was also dissimilar. To bolster their claims, the ammunition found in the car was usable by the murder weapons in question. Carter and Artis were taken to police headquarters, where they were questioned. Surviving witnesses did not identify them as the perpetrators, and they were released. Carter and Artis appeared before a grand jury voluntarily. The jury did not return an indictment. Months after this was settled, however, Alfred Bello disclosed to the police that he had an accomplice for his burglary the night of the Lafayette murders. His name was Arthur Dexter Bradley. After further questioning, Bello and Bradley fingered Carter as one of the two males they had seen carrying weapons outside the bar the night of the murders. Bello cited Artis as the other suspect. Based on this anecdotal evidence, Carter and Artis were arrested and indicted. The case went to trial in 1967. As Carter and Artis' attorneys endeavored to convince the court of their innocence, their case for Carter's innocence was daunted by the biases of racism, evident both in the actions of judges and in the verdicts of the all-white juries. Case in point, Carter's attorney, Raymond A. Brown, shed light on some discrepancies in descriptions given by eyewitnesses Marins and Bello. Brown also outfitted their case with several witnesses who testified that Carter and Artis were at a nearby bar called the Night Spot at the time of the shootings. Despite Brown's best efforts, Carter and Artis were convicted. The prosecution was keen to secure the death penalty, but the jury recommended that each of them serve a life sentence for each murder. Judge Samuel Larner sentenced Carter to 2 consecutive life sentences and another to be served concurrently. Artis was sentenced to 3 concurrent life sentences. One glimmer of hope emerged in 1974, when Bello and Bradley recanted their identifications of Carter and Artis as the suspects in the murders. Their recantations were used as the basis for a motion for a new trial. Judge Larner denied the motion on December 11th. His reason was that he felt the recantations, quote, lacked the ring of truth. As Carter served his sentence, advocates took up the cause to gather public support for a retrial or pardon. One such advocate was Madison Avenue advertising guru George Lois. He organized a campaign and attracted not only members of the general public, but celebrities like boxer Muhammad Ali and singer Bob Dylan, who wrote the song Hurricane. The song proclaims Carter's innocence. Dylan even performed the song as part of a concert at Trenton State Prison, where Carter was temporarily remanded. During a hearing on Bello and Bradley's recantations, they argued that they had lied during their trial of 1967. They told the jurors that they made narrow, limited deals with the prosecutors in exchange for their testimonies. One detective recorded an interrogation of Bello in 1966. As it was played during the hearing, attorneys for the defense argued that the tape revealed promises that expanded beyond the perimeters of what Bello had claimed in his testimony. This imposed the possibility of a Brady obligation on the prosecution. In American law, a Brady obligation, also known as a Brady disclosure, consists of exculpatory or impeaching information and evidence that is material to the innocence or guilt or to the punishment of a defendant. By law, the prosecution was required to disclose the evidence or had a duty to disclose that their witnesses perjured themselves. Consistent with his record, Judge Larner denied this argument. However, the New Jersey Supreme Court unanimously voted that the evidence of deals made between the prosecution and the witnesses should have been disclosed to the defense before or after the trial of 1967. They determined that the evidence in question could have, quote, affected the jury's evaluation of the credibility of the eyewitnesses. To quote Justice Mark Sullivan, the defendant's right to a fair trial was substantially prejudiced. The court set aside the original convictions. Carter and Artis were granted a new trial. Prosecuting a 10-year-old case presents many challenges, but prosecuting attorney Burl Ives Humphreys decided to try Carter and Artis again. Keen to avoid using perjured testimony to obtain a conviction, Humphreys had Bello undergo a polygraph test. He was tested twice, once by Leonard H. Harrelson and again by Richard Arthur. Both Harrelson and Arthur were prominent and respected experts on the science and methodology of polygraph examinations. According to their results, Bello's answer to the question about whether he had seen Rubin Carter outside of Lafayette immediately after the murders was non-deceptive. There was an important caveat to bear in mind. Harrelson reported in a spoken statement that Bello had been inside the bar shortly before and after the time of the shooting. This contradicts the statement he made during the 1967 trial, whereupon he said he had been on the street at the time of the murders. Despite this contradiction, Harrelson submitted a written report stating that the testimony Bello gave during the 1967 trial was non-deceptive. Second conviction and appeal. During the new trial, Alfred Bello repeated the testimony he gave in the trial of 1967, in which he identified Carter and Artis as the two armed figures he saw outside of the Lafayette Grill. Arthur Bradler refused to cooperate, and he was never called as a witness to testify by either the defense or the prosecution. The defense produced multiple witnesses who testified that they identified Carter at the locations where he claimed to be present at the time of the killings. Investigator Fred Hogan, who was responsible for the recantations of Bello and Bradley, appeared as a witness for the defense. Hogan was asked when cross-examined if any bribes of inducements were offered to Bello in exchange for his recantation. Hogan denied this. His handwritten notes on his conversations with Bello were entered into evidence. The defense also shed light on inconsistencies in the testimony of Patricia Valentine. Additionally, they read aloud the 1967 testimony of William Marins, who died in 1973. His descriptions of the murderer's physical profiles and mode of dress were at variance with the way Carter and Artis appeared at the time. Other damning testimony came from an associate of Carter's, who reported that Passaic County prosecutors pressured her into testifying against Carter. Prosecutors denied her allegations. The jury, comprised of Caucasians, as always, deliberated for 9 hours. Carter and Artis were found guilty once again. Judge Leo Pizzi reimposed the same sentences that they received before. A double life sentence for Carter and single life sentence for Artis. Artis made parole in 1981. Carter's attorneys launched an appeal, a process that took years. In 1982, the Supreme Court of New Jersey affirmed his convictions 4-3. While the justices agreed that the prosecutors should have disclosed Harrelson's oral opinion about Bello's location at the time of the killings, only a minority thought this was material. The majority concluded that the prosecution therefore had not withheld information that the Brady disclosure law required they provide to the defense. Carter was released on bail in March 1976, but his troubles were far from over. In fact, they were exacerbated by his own conduct. Bail bondswoman Carolyn Kelly helped to raise funds to win Carter a second trial, a victory that led to his release. According to Kelly, Carter assaulted her severely during a fundraising trip a month later. A dispute over a hotel bill was reported as the instigating factor. The support he received from celebrities waned considerably after the incident was reported by the Philadelphia Daily News. Carter denied the allegation. There was not sufficient evidence to convict him. Other personal troubles beset Carter. May Thelma Baskett, Carter's wife since 1963, divorced him following the birth of their second child after discovering he had been unfaithful. Federal Court. Carter's attorneys filed a petition for a writ of habeas corpus in federal court. In 1985, Judge Haddon Lee Sorokin of the United States District Court for the District of New Jersey granted the writ. He noted that the prosecution had been, quote, predicated upon an appeal to racism rather than reason, and concealment rather than disclosure. He set aside the convictions. Carter, 48 years old at this point, was freed without bail in November of that year. Prosecutors appealed Sorokin's ruling to the Third Circuit Court of Appeals. They also filed a motion with the court to return Carter to prison, where he might remain until the outcome of the appeal would be decided. The motion was denied by the court, and they upheld Sorokin's opinion, thereby affirming his Brady analysis without commenting any further. The prosecutors were undeterred. They appealed to the United States Supreme Court. The court declined to hear the case. The prosecution had the option to try Carter and Artis a third time, but decided against it. Instead, they filed a motion to dismiss the original indictments. To quote New Jersey Attorney General W. Carey Edwards, "It is just not legally feasible to sustain a prosecution, and not practical after almost 22 years, to be trying anyone." Acting Passaic County Prosecutor John P. Gosalak noted that several factors negated the possibility of a retrial, including Bellow's, quote, current unreliability as a witness. It also didn't help that there were no other witnesses available. He was also skeptical about the possibility that the prosecution could reintroduce their racially motivated crime theory due to the federal court's rulings. A motion to dismiss was granted by the judge. This brought about an end to all of Rubin Carter's legal proceedings. Life after emancipation. Rubin Carter moved to Toronto, Ontario, Canada. Whilst living there, he became a Canadian citizen. After having benefited from the advocacy of others while he was a victim of a travesty of justice, Carter took up the cause himself. He became involved with the Association in Defense of the Wrongly Convicted, or the AIDWYC. He served as executive director starting in 1993. He resigned in 2005 when the organization refused to side with him in his opposition to the appointment of Susan McLean to a position of judgeship. He gave as his reason the fact that she was the prosecutor of Canadian Guy Paul Morin, who served over 18 months in prison for rape and murder until he was exonerated by DNA evidence. Carter remarried, this time to Lisa Peters. The marriage was short-lived. Rubin would experience one final incident of being falsely accused of a crime he didn't commit by law enforcement. In 1996, when he was 59 years old, he was arrested by Toronto police when they confused him with a suspect who was believed to have sold narcotics to an undercover police officer. Once they discovered they were in error in identifying him as the suspect, they released him. Carter dedicated much of his time during his later years to serving as a motivational speaker. This included appearances at high schools. On October 14, 2005, 2 honorary doctorates of law were bestowed upon him. One was from York University in Toronto, and the other from Griffith University in Brisbane, Australia. These honorifics were issued in recognition of his advocacy with AIDWYC and the Innocence Project. The Innocence Project exonerates the wrongly convicted through DNA testing. Their long-range goal is to bring about reforms to the American criminal justice system that will prevent future injustices. Carter also received the Abolition Award from Death Penalty Focus in 1996. final years. While attending the International Justice Conference in Burswood, Western Australia in March 2012, Carter revealed that he had been diagnosed with terminal prostate cancer. The prognosis given by doctors forecasted that he had 3 to 6 months to live. Soon after the diagnosis, John Artis moved in with Carter and became his caregiver. In the months leading up to his death, Carter invested his time in working for the exoneration of David McCallum, a native of Brooklyn, New York. McCallum had been incarcerated since 1985 on charges of murder and was believed to be wrongfully convicted. 2 months before his death, Carter published an opinion piece in the New York Daily News entitled Hurricane Carter's Dying Wish. Within the piece, he requested an independent review of McCallum's conviction, appealing to anyone among the public who might be inspired to take up the cause. To quote Carter, "I request only that McCallum be granted a full hearing by the Brooklyn Conviction Integrity Unit, now under the auspices of the new District Attorney, Ken Thompson. Knowing what I do, I am certain that when the facts are brought to light, Thompson will recommend his immediate release. Just as my own verdict was predicated on racism rather than reason, and on concealment rather than disclosure, as Sorokin wrote, so too was McCallum's." On April 20th, 2014, Artis confirmed publicly and privately that Rubin Carter had succumbed to his illness. In October of that year, David McCallum was exonerated. Rubin Carter reflected on his life in a speech he gave as a motivational speaker.
You were in that prison cell for a crime that you did not commit. Did you ever give up hope? Was your spirit ever broken?
If I gave up hope for 1 second, I would not be sitting here with you today. But see, I went to prison for a purpose for a reason that I did not do. So therefore, my introduction into the prison was quite different than someone who may have committed a crime and gone to prison, because then you just ease your way into prison. But my time in prison was I refused to act like a criminal. I was innocent of this crime, and I refused to act guilty. And I refused to allow people to treat me as I was guilty. So I wouldn't wear their clothes, I wouldn't eat their food, I wouldn't work their job. I wouldn't do anything for a prison, because everything about a prison is for the prison and not for me. So that was the situation that I was in when I went to prison.
Now, it's funny because we were talking, we were watching you as you spoke, and the children, you had the photographer Brad said you had them captivated, you had them in the palm of your hands. Did you ever know this prison, which was your misery at the time, would wind up becoming your ministry?
Wow. That's a difficult question. No, when I was in prison, all I wanted to do was survive it. You know what I mean? I wasn't looking for a future. I was dealing with the here and the now, because that was most important to me. But that's what the magic is all about, because here I am 41 years later, and I'm a doctor, a double doctor. You know, I talk to children. It's wonderful. Life is wonderful. But you really got to enjoy it. You really got to do that.
How was it having your life story told in a movie, and to have Denzel Washington, of all people, playing you? That'd be like Halle Berry playing me. You know what I mean? So tell me, how was that for you?
Well, my life has been of such that I've fortunately have had books written about me, songs written about me, movies made of me. All while I'm alive. I mean, that is miraculous. It's a miracle. My life is a miracle, and that's the way I live it, and that's what I try to give to other people, to let them know that they are as miraculous as this planet Earth is miraculous.
David McCallum, The Crime. October 20th, 1985, Queens, New York. Nathan Blenner, 20 years old, is forced into his car and kidnapped. The following day, his body was found in Aberdeen Park in Brooklyn. He had been dispatched with a single bullet in the head. His car was located on October 22nd by a security guard when it was found burning on Fulton Street in Brooklyn. After canvassing Blenner's neighborhood, police questioned a woman who claimed that about an hour before the murder, she was washing her car on the street about a block from Blenner's home. According to her statement, 2 black men walked by and one remarked that she had a nice car. Her reply was that if the car wound up stolen, she would, quote, know where to look. She described the men as being in their 20s. One of them had braided hair. She estimated their height as being 5 feet 10 for the taller one, and the shorter being at 5 feet 6. The police asked her to go through several police books of mugshots of robbery arrestees, but she was not able to identify anyone. Soon after, police questioned Terrence Howard and Herman Mumford. They were both in their 20s. They were queried about a series of carjackings that occurred in Brooklyn prior to Blenner's abduction and murder. When questioned about the Blenner case, they denied that they were involved. Howard and Hayward told Detective Joseph Buta that he knew a 16-year-old named Willie Stuckey who had recently given a gun to James Johnson. Stuckey claimed the gun, quote, had a body on it, meaning it had been used to commit a murder. Johnson then led police to Stuckey and a friend of his, David McCallum, also 16. David McCallum and Willie Stuckey were questioned on October 27, 1985. Detective Buta reported that they both confessed to carjacking and killing Blenner, though many of the details of their confessions did not match the clues that were noted at the scene. Stuckey said McCallum killed Blenner and that he shot him 3 times. McCallum, by contrast, said that Stuckey killed Blenner and that the murder consisted of only 1 shot. Stuckey also confessed that he and McCallum approached the woman washing her car and expressed their appreciation of the quality of the vehicle. Both men said that Blenner was shot at night. This is inconsistent with the coroner's findings, which indicated after the autopsy commenced that Blenner was shot during the day shortly after the abduction. McCallum and Stuckey recanted their confessions almost immediately and claimed that they were slapped by the detectives who questioned them. McCallum also reported that the detectives went as far as to threaten to hit him with a chair if he did not confess. Both McCallum and Stuckey were offered prison sentences of 15 years to life if they pled guilty. They rejected this offer. They opted to take the case to trial, and it was heard in Kings County Supreme Court in October 1986. No physical or forensic evidence linking them inexorably to the crime was ever presented. There were no witnesses of the crime itself, and therefore no one came forward to identify McCallum and Stuckey as the culprits. The primary evidence against them was their confessions. It was considered admissible despite their recantations. On October 27, 1986, a jury convicted them both of second-degree murder, first-degree kidnapping, first-degree robbery, and criminal use of a weapon. They were both sentenced to 25 years to life in prison. Attorneys for both McCallum and Stuckey attempted to appeal the decisions, but the appeals were denied. Willie Stuckey died of a heart attack in prison in December 2001. McCallum continued to challenge his conviction using all legal recourses available, but was unsuccessful. In 2001, attorney Oscar Michelin asked Kings County District Attorney Charles Hines to submit McCallum's case to his Conviction Integrity Unit. Following this move, DNA on cigarette butts and a marijuana roach found in Blenner's car was analyzed. Blenner was known to strictly forbid smoking of any kind in his car. A DNA profile of a man with a criminal record was identified. Neither McCallum's nor Stuckey's DNA was found in the car. Amid Michelin's reinvestigation of the case, he discovered a record of the police interrogation of Terrence Howard and Herman Mumford. The interrogation transcript had not been disclosed to McCallum and Stuckey's defense attorneys prior to their trial. In August 2013, Charles Hines' office informed Michelin that the office concluded there was no evidence to support McCallum's claim that he was innocent. In autumn of that year, after Hines was defeated in his bid for re-election, Michelin wrote to Kenneth Thompson. Thompson had just been elected to the position of district attorney. Michelin implored Thompson to take another look at the McCallum case. In April 2014, Rubin Hurricane Carter sent a letter to Thompson stating that it was his dying wish for him to review McCallum's case anew. To quote the letter, "My aim in helping this fine man is to pay it forward, to give the help that I received as a wrongly convicted man to another who needs such help now." Before the court date, Thompson was quoted as saying the admissions were false in large part because these 16-year-olds were fed false facts. On October 15, 2014, Thompson moved the Kings County, New York Supreme Court to vacate the convictions of both McCallum and Stuckey. The motion was granted, and all charges against both men were dismissed in toto. Upon this decision, McCallum's release was secured. McCallum put his head on the defense table and wept. His entire body shook as he heard the judge speak. Stuckey's mother placed her hand on his back. Thompson indicated that the confessions were clearly false, having been obtained through coercion. He went on to criticize his predecessor, Charles Hines, for failing to seriously address the claims of innocence. To quote Thompson, "I inherited a legacy of disgrace with respect to wrongful convictions." McCallum left the courtroom with his arm around his mother, Ernestine McCallum. He received applause from supporters and hugs from relatives. He was 45 years old. He had spent almost two-thirds of his life in prison. Having received the news of McCallum's exoneration, Nathan Blenner's family were both stunned and dismayed. To quote his sister, Dr. Deborah Blenner, "We were led to believe for 29 years that they're the killers. They confessed." She went on to say that her family found it troubling that a review by the district attorney's staff and an advisory panel of outside lawyers could upend a jury verdict that appeal courts upheld. McCallum followed up his exoneration and release by filing a claim for compensation with the New York Court of Claims. He is the subject of a documentary film entitled David and Me. He had this to say about his experience during a press conference immediately following his release.
Feeling like I want to go home, finally, after 29 years. And of course, this is a bittersweet moment because I'm walking out alone. There's someone else. There's someone else who's supposed to be walking out with me, but unfortunately he's not, and that's Willie Stuckey.
How do you feel having lost 3 decades of your life for something you didn't do?
Well, I've had a long time to think about that, and unfortunately. So, but at the same time, I think I'm mature enough to understand that I can't get that back, and I won't even attempt to get that back. I think my life kind of starts, from this point on.
Ken Klonsky is an advocate for the wrongfully convicted. He has written 2 nonfiction books on the subject, one with Rubin Hurricane Carter entitled Eye of the Hurricane, My Path from Darkness to Freedom, and Freeing David McCallum, The Last Miracle of Rubin Hurricane Carter. He also wrote a novel inspired by wrongful convictions called Life Without. His official website is www.kenklonsky.com, KenKlonsky.com. He joins us via Skype from Vancouver, Canada. So thank you very much, Ken, for joining us, and I appreciate this, and I know you're an expert on the subject. So one thing I was wondering is, not having been a victim of a wrongful conviction yourself, what inspired you to take up the cause as an advocate for persons who have been affected?
It was quite a roundabout experience. I had a class at Vaughan Road Academy. I guess at the time you were there.
Yeah, that's right.
And they were reluctant readers, people whose main interest was not schooling. And I took them to see a film, The Hurricane by Norman Jewison. It was about Rubin Hurricane Carter, and it starred Denzel Washington, maybe his best role. And the kids knew that he lived in Toronto, although nobody knew where he lived. And I said, well, maybe I can find out, and we can invite him to the class. So they were all excited by this. They wrote letters, and he agreed to come, I was shocked. I just figured it would be a kind of perfunctory exercise, and he would refuse. So he came to the class quite unexpectedly, and he gave a session. Nobody really understood much of what he was saying. He had his own particular metaphysical ideology or cosmology. I mean, it'd be hard to give a description for it, but I certainly didn't understand much of what he said. And that was not the issue. The issue was he was there, and he validated these kids in a way they had never been validated before. They felt, well, if he comes to see us, then we feel important. And a lot of them did quite well as students after this. I actually followed. I tracked it, and a number of them graduated. A large number of them did. In fact, I'd come to say maybe 80-90% of them, when normally half of them would have gotten through the schooling. So I come to think that it really was him. He made a huge difference. Afterward, I asked him to do an interview for a magazine called The Sun magazine, and he agreed to do it. And he really liked the way it turned out. And to make a long story short, I started pushing him about doing a book based on the same ideas. And these were ideas that he had started to interest me, that started to interest me while he was in the class. I know this is a long answer, but at the same time, he resigned from the Association in Defense of the Wrongly Convicted, AIDWC, as it was known at the time. It's now called Innocence Canada. He resigned because he was having a dispute with them. And so my friendship with him arose at the very time he was leaving the organization he'd given his name to. Or let's put it this way, he'd given not his name, but his prestige to. And he had a lot of prestige. So he had no place to go, really. He was out in the wilderness, and I always say that he was like he was like Don Quixote, and I was Sancho Panza, following him into whatever messes I might find myself. And the first one was a man named David McCallum, who wrote to tell us that he had been wrongly convicted and he was sitting in prison in New York State. And so I, not knowing anything about wrongful convictions, I thought, well, I'd seen that film. I know it's a terrible thing that somebody is thrown in prison for something they haven't done. And I wrote him back. I wrote David McCallum back, and he basically, I said, Rubin is interested in your story. Send it to us. See what, we'll tell you what we think. And so he sent his full story. It was a kind of autobiography. And Rubin kind of took to him in the tone and everything. It says, well, we'll make him our first case. And at that point, it was a great excitement for David, but we still hadn't visited him. And Rubin would never take up anybody's cause who he hadn't visited. So we went to the prison in New York State, and that was really the beginning of my work in wrongful convictions, because David became our first client.
And you have written books about individual cases of wrongful convictions. Could you tell me about each one of them in terms of the titles and the thesis of each book? 3 of them came up on Amazon. That's the ones I've seen.
The first book was with Rubin. It was written with Rubin Carter. It was called Eye of the Hurricane. My mind just lost that one. Eye of the Hurricane, anyway. And he wanted somebody to help him get his thoughts down on paper and his history. And I was a writer, so it I was the natural person to do it. And we did the book together, and it came out in 2011 with Chicago Review Press. Then I did a novella, which the scenario was made up, but the details of Wrongful Conviction are in there. It's called Life Without, and that title refers to the sentence that's given to people in certain states who are convicted of murder, and they're not given the death penalty. So they're given life without the possibility of parole, which we always saw as another kind of death penalty, because people in prison are the living dead. And the last book is the book that I put out in 2018. It's called Freeing David McCallum, The Last Miracle of Rubin, Hurricane Carter. So it was after Rubin's death, and kind of put the cap on the entire episode and the life and the since the time I met David McCallum back in 2004 and when we got him out in 2014.
And this is something that's likely happened in Canada, but the problem seems to be more widespread in the United States. What is your verdict on the American justice system in terms of the causes of wrongful convictions after all the research you've done on the topic?
The American system is no different than the Canadian one with respect to wrongful convictions. I'd be very careful about that caveat. Legal systems everywhere try to suppress wrongful convictions, everywhere, because it makes them look bad to have convicted somebody wrongfully. And there's also sometimes very large financial settlements that they're embarrassed about, or they may not be reelected because a lot of district attorneys are elected in the United States. So admitting error is bad for one's career. Also, to convict someone in a high-profile crime. Right now, the Central Park 5 case is on Netflix again, and you see the ambition of police and prosecutors who want to get their careers, they want to get political careers, financial careers with big law firms, so they are careless in some of the work that they do. They wind up, Canadian prosecutors and police do the same thing. The wrongful convictions will always occur. The major problem is that they're so hard to overturn because so many people have a vested interest in them. So even a terrific innocence project, the average time it takes to free somebody when the Innocence Project gets involved is 10 years. That's how tough the system is to go up against. As far as the differences in Canada and the U.S., Canada has 40,000 prisoners at any given time. The United States has 2.3 million. So the proportionate effect, Americans should have no more than 400,000, and they've got 2.3 million. So the USA overuses prison, and Rubin's theory, which I believe is true, it's partially a method of population control. It's racism. The more blacks or Hispanics that are in prison, the less children they're going to have. Now, if that doesn't sound cynical, I don't know what would, but I hate to even say such a thing, but there is truth to it, especially in the South in the United States.
And one bit of terminology that's come up that I found intriguing is unsafe. Some convictions have been deemed, quote-unquote, unsafe. What does that mean?
Simply that when you look at them, you see all the signs of a wrongful conviction, or even some of the signs of a wrongful conviction.
And how much connection is there to the police themselves? Because I know sometimes a crime could be committed. And this happened with the West Memphis 3, where there was so much pressure on the police from the community to find the culprits who murdered these 3 little boys that they scapegoated these 3 teenage boys without any concrete evidence. Do you find that's a factor as well, where the police just want to get the public off their back and they'll scapegoat the most convenient suspect available?
Yes, that's the case, it's certainly in the case of David McCallum. He and his friend Willie Stuckey, there was zero evidence. And like the Central Park 5, their confessions were manipulated and enforced or forced. There is, at least the Central Park 5 were in Central Park that night. David and Willie weren't anywhere near. They'd never even been in Queens where the kidnapping took place. And David spent 29 years in prison. So yes, the pressure, especially if a white person is killed, the pressure to killed by maybe the notion that it was killed by a black person, the pressure is huge. And it's also very convenient to find a suspect who perhaps has no relationship to the crime, because many people believe out of hand that a black person would do this crime without even examining the facts.
And the law is looked upon with awe and respect by officers of the court, when in fact it's simply a tool. So what do you feel needs to change about the way that the law is enforced?
Well, the law is a law. It has to be enforced. Certainly the police do that job. And most convictions are proper. I would have to say that the large majority of cases results in a correct conviction. The problem is when, and I can't stress this enough, the problem is when police and prosecutors go beyond the constitutions in various countries. The constitutions protect the average citizen from police malfeasance, especially the idea of confessing to a crime. They read you your rights. Okay, that itself was deemed to be a constitutional necessity in the United States, called the Miranda rights. That does not exist in Canada. But even in the United States, where you can be read your Miranda rights, you can still wind up saying things that are completely against your interests because you don't have a lawyer present. They make it very inconvenient for you to get a lawyer, or you're too young to know that you have that right. But these rights are the foundation of democracy. Like habeas corpus, these rights should never be treated lightly in order to get somebody into prison and satisfy the public.
And what do you find is a common denominator in terms of choosing a scapegoat to frame for a crime? We talked about race earlier. What other considerations tend to become significant factors in that process?
Prior convictions and poverty, class. So a person who's poor is more likely to be wrongly convicted or framed, scapegoated. They have less ability to protect themselves.
And many feel these days that criminalization of black life and the mass incarceration of black people in the United States has become the new slavery. Do you agree with that assessment of the situation?
Interesting. Michelle Alexander calls the incarceration epidemic, and 2.3 million people in prison even exceeds percentages in China. And China is a police state, in my view, by and large. She calls this the new Jim Crow, which goes back to post-slavery Reconstruction. There is slavery, and the slavery consists of working at industry for practically no wages. For example, the manufacture of army helmets in the United States is done in prisons, mattresses, and these jobs pay 14 cents an hour. I did hear of one job in a prison that was 28 cents an hour, and that's kind of considered Park Avenue wages inside the prison. But imagine the profit that a company makes by employing prisoners.
Prisons in the United States were privatized years ago, and on the heels of the privatization, mandatory minimum sentences have become more extreme, with people being sentenced to life or decades for nonviolent crimes. Lawmakers with ties to corporations that own prisons have received incentives to adjust the laws to fill the prisons with more and more inmates. Do you feel sentencing has become too extreme in America? Does the punishment always fit the crime these days?
Privatized prisons are not exclusively, in other words, let me put it this way. There are privatized prisons in the United States, but they don't represent the vast majority of prisons. Most of them are state prisons. Yes, if you privatize prisons, what they do is cut corners, and they make profit off these people. It's fairly disgusting, and also the sentences allow them to profit for long periods of time. One should be cynical about the privatization of prisons. But what many people don't really know is that there are many companies, and this is in the public prisons, that get rich by winning exclusive contracts to provide clothing, decent food, electronics, and so forth through relatives and friends of prisoners. So if I want to get clothing to one of our clients, or if I want to get food, I have to go through one company. In each prison, there's only one company you can go through. And so the prisoners are cash cows, and their being in prison serves those companies. And I must say that in many cases there are kickbacks provided to politicians and maybe even prison officials. I don't know that for certain, but politicians for sure. And it costs taxpayers a lot of money to have these people in prison for such a long period of time. But who's making the money? The money is being made by these corporations that supply prisoners.
And what have you found is the long-term effect psychologically of having done all this time while being innocent? Has it changed these individuals, have you found?
Oh, well, I think that's obvious, yes. I'll give you one example. David McCallum, who's one of the nicest people I've ever met, and certainly many people feel that way about him. And I'm not exaggerating when I say that. He has a very hard time beginning things, getting projects off the ground, going out and researching or finding a way to even buy certain things. Because when you're in prison for 29 years, or even half that time, you lose your autonomy. You're told what to do every single day, and where to be, and what to eat, and you have no decision making that really matters. I don't even know that you can decide whether to behave or not. But what happens when you leave the prison is that follows you. You are still incapable of making decisions. So for me, that's the number one sign of a person who'd been incarcerated for too many years.
Have you found that that bitterness is a factor? Do they end up developing, a great deal of unresolved anger toward their country, the justice system of their country?
Well, it must be there, but I have to admit I haven't seen it. I've met many wrongly convicted people who've left prison, and I've yet to see somebody with huge amounts of anger. Now, that doesn't mean that they don't feel it deep down. I think they do, and sometimes it comes out in strange ways. There's a case in California that Rubin was involved in where they helped a guy get out of prison, he and his friend, and they were convicted in the same case. And the friend went out and committed a rape and was put back in prison for the rest of his life. I mean, they were only too happy to get him back in there. But the problem was his issues of anger and resentment were totally unresolved, and he should not have been out in the street. That case caused Rubin to make the character of the person in the one who's wrongly convicted, the character becomes an essential. So, innocence is the first item, but the person's character is equally important, 50%, because you don't want to represent somebody who's going to go out and commit another crime. It destroys your reputation.
So I'm just going to mention how your books are available. So I mentioned that they're on Amazon. So there's Freeing David McCallum, Eye of the Hurricane, and Life Without. So what other ways can listeners come into a copy of any of your books? Are they out in the stores?
Well, yeah, depending. If you're living in a city like Toronto, probably so. I would prefer, not that I'd make more money or anything, but I would prefer that people did go through bookstores, at least order through bookstores. As a writer, I have not only an interest in keeping bookstores going, but a respect for people who go out of their way to set up a business and where people are comfortable and so forth. Amazon is an extraordinarily rich corporation, and it doesn't need my books, even though they do appear on Amazon. They are not. They shouldn't be the biggest distributor of books in the United States, and I'm afraid they are.
Oh, absolutely. And what is your official website?
KenKlonsky.com.
And that contains a lot of information about wrongful conviction cases?
Yeah, it does. And also issues around it. Also films and various things that are happening right now in this field. For example, there's causes of wrongful convictions, but there's also an issue about wrongful acquittals. And so cases like Colin Boushey, which there's a film out about him right now, and Trayvon Martin, where these men were murdered and they never got justice because they happened to be of the wrong race. The case of Trayvon Martin is certainly one of the most egregious pieces of injustice, where he was murdered by a guy in a housing. I mean, this perfectly innocent kid goes out and buys something and comes back in, and he's confronted by basically, in my view, this Zimmerman guy who's a total hooligan, and he's shot and killed. He gets off. This is, to me, just as bad, every bit as bad, and maybe even worse than a wrongful conviction. These things are on the website, so I try and make it as general as possible.
Have you looked into the inner workings of police culture? Do you have any ideas of why these things keep happening? Why is there so much aggression coming from police to minority groups? Does that profession attract people like that, or do you feel there's something about it that makes allowances for it?
Well, both. Some police are power hungry and they want to get back at certain things or certain people in society, but a lot of those people are weeded out. By and large, my experience with police is that most of them are decent people. They want to do a good job, and they don't want to have falsely or wrongly convicted people. But when there are two things that get in the way, one is a lack of education, and two is ambition. And once they want to get their names out there as the person who's put such and such behind bars, certainly the case in Central Park 5, if that's the case, then they start to behave in a way that, or they could just be, down and out racists, and they weren't weeded out when they were interviewed for the job. So their ignorance of the law, there's a whole slew of problems but I don't think it's the majority of police. But at the same time, I don't think it's like a bunch of, a few bad apples. The culture of police forces, military, kind of macho, patriarchal, this kind of stuff leads to abuse as well.
That's right. In any profession where people are allowed to express aggression, where the aggression may occasionally be required, like even in sports, like in boxing, a lot of boxers have abused their wives, for instance. It seems like you can't put that toothpaste back in the tube in some instances.
Yeah, violence in sports. Yeah, you can't separate that sometimes. It's not like you can live two different lives. It's true. If you've learned violence in one area, perhaps it's a hell of a lot harder to repress it in another area if violence is the way you make a living. Now, I don't really know what percentage of boxers or football players actually are violent because all you hear about is the cases where they've committed violence against their wives or whosoever. And it may be that a large majority of them have they don't do such a thing, but you certainly hear about the cases when they do. I did want to mention the Netflix, certainly the bit about that's just come out around Central Park 5. I would recommend people seeing When They See Us. It's a pretty powerful and disturbing piece. And it's on Netflix right now. It's just come out, and it's about the Central Park 5 and how these kids were forced to confess. David McCallum's story is a TVO story called David and Me, and it's on Netflix in the U.S. under the title Fight for Justice, David and Me. These films, also the confession tapes on Netflix, with our clients Atif Rafay and Sebastian Burns. These films show how young people can be fooled into confessing to crimes they haven't committed.
All right. Well, I thank you so much today for your expertise and for your time. I really appreciate it, Ken. Thank you so much.
All right, Morgan. It's nice hearing from you.
Yeah, it's nice hearing from you. Take care, man. Thank you for listening to Human Monsters. This is Morgan Rector.